This question looks at fraudulent and wrongful trading. So the scenario here, we've got two directors, Fran and Graham, F and G. They registered a private limited company and each of them is a director. Now the company made a small profit in the first year, second year of trading it made a loss. At this point, Fran said he wanted the company to cease trading. Graham was insistent that they should continue. So what happens, Graham continues and Fran takes less of a part in the day-to-day management of the company. However, he does remain as a company director. What then happens? Well, Graham then falsifies the accounts for a period of 3 years to disguise the continued losses. Eventually, it becomes obvious there's no alternative. We're going to go into liquidation and there are debts. So the first task is about wrongful and fraudulent trading. What type of action is taken? Is this civil, criminal, or both? So just as a reminder, civil action, the objective is to compensate the injured party, whereas criminal action, the objective is to punish the wrongdoer. Now, in terms of our definitions of fraudulent and wrongful trading, so both of these fall under the Insolvency Act 1986. And fraudulent trading is when a director or anybody else carries on trade with the intention of defrauding creditors. Wrongful trading, on the other hand, takes place when a director or a shadow director should reasonably have known that there was a problem with the company's liquidity. Now note therefore the difference. Fraudulent trading there is intention. Wrongful trading there doesn't have to show intention, just reasonableness. Now in terms of what does this mean in terms of civil and criminal liability, so fraudulent trading can be a civil case, but it can also be criminal. So it's both civil and criminal. So somebody, an injured party, a creditor can take action against the directors, but the state can also take criminal action against the directors to punish them. Whereas wrongful trading is a civil offence only, and you would not normally expect to be prosecuted and punished for wrongful trading. So for task 2, we've already talked about the definitions of fraudulent and wrongful trading under the Insolvency Act. So what is the situation here? Well, which applies? In the case of Fran, well, Fran was not actively involved in running the company. Fran was taking less of a part of the day-to-day management. There's no evidence that Fran was deliberately committing fraud. However, as a company director, he should reasonably have been aware of this. Stepping back and being ignorant is not a valid defence. The fact that the company had been struggling, the fact that Fran thought the company should be wound up and allowed it to continue means that you could look at a charge of wrongful trading for Fran. Graham, on the other hand, is different. Graham, there is a clear intention because he's falsified the accounts. That falsification makes this fraudulent trading.